Hello again. This is Russell Kohn of the Kohn Law Office in Oceanside, California, where we only handle personal injury cases. Today, we want to talk about how to win your slip or trip and fall case. In legalese, these are called premises liability cases. Often these cases involve serious injuries such as fractures and ligament tears that need significant medical attention and even surgery. At the Kohn Law Office, we are experts at handling these difficult cases. Often we get calls from potential clients who've been rejected by other attorneys. Often these are good cases, but the other attorneys shy away from these cases because of the liability challenges and the potential for litigation and high costs. No doubt these are sometimes difficult cases which wind up in litigation. These are tougher to win than clear liability rear-end auto accident cases or strict liability dog bite cases. But if the cases are handled correctly from the beginning, then the costs can be kept minimal and liability can be convincingly established. Where other attorneys see a lump of coal, often we see a diamond in the rough. Recently, the Kohn Law Office has won cases involving slip and falls at large department stores and grocery outlets, such as Sears, Fry's Electronics, Ralph's Grocery Store, Seafood City, and Smart & Final. We've also won cases involving trip and falls at shopping centers, hotels, and restaurants, such as the Westfield Mall, Shakey's Pizza, and McDonald's. Here are the important elements in a successful premises liability case. Number one, reporting the incident to the property manager or owner as soon as possible. Two, gathering witness information. Three, documenting the scene and the dangerous condition promptly. Four, obtaining prompt medical attention. And then five, contacting an experienced personal injury attorney promptly. Let's go through these elements one at a time, and I will explain why they are so important to the case. First, it is always best to report the incident to an employee and request that an incident report be prepared. Many times people are embarrassed that they've fallen and believe it's their own fault, so they choose not to insist upon an incident report being taken. And they also refuse to go to the hospital by ambulance. The problem is that later they find out that their injuries are more significant than they initially thought. They're going to need a lot of medical care and maybe take a lot of time off work. During the first call to our office, we ask if an incident report was prepared. If it was not, we recommend that the injured person immediately report the incident to the property manager or the owner on their own. It doesn't look good for the first report to be from an attorney. Many business establishments also have video surveillance, which overwrites itself as often as every couple weeks. If the incident is not reported during that time frame, the video may be lost forever. When an incident is reported, a business establishment usually has a policy that any video surveillance of the incident be preserved. It is extremely important to have video not only of the fall itself, but also of how the condition occurred. Does the video show an employee creating the condition or the length of time that the condition existed before the incident occurred? The answer to those questions can determine liability of the business establishment for the injury. Next, number two, let's discuss why gathering witness information is so important. Many times people are out at a business establishment, such as shopping centers or restaurants, without friends and family. However, eyewitnesses to the incident are important to determining liability for the dangerous condition that caused the injury. Other customers or patrons of the establishment may even stop and provide help, but not leave their name with the injured victim or the business establishment. It's always helpful to have the names of those independent eyewitnesses when recreating the events of the incident. It is also important to know the names of any employees of the business establishment that provided assistance or witnessed the incident. These employees may not be listed in a report, even if one is prepared. It is very difficult to go back in time to the establishment after the fact and try to determine which employees witnessed the incident or the aftermath. It can save a lot of money on hiring private investigators if that information is already known. These are people that the attorney will want to contact and get statements from in order to establish liability and hopefully avoid costly litigation. Point number 3, documenting the scene and the dangerous condition promptly is very important because things change over time. The business may repair or alter the dangerous condition and then deny that it even existed. For this reason, we want to get photographs of the scene and the condition that caused the injury as promptly as possible. Often the injured party doesn't take adequate photographs of the scene. If there's no video surveillance of the incident, then photographs are extremely important to document the condition. Testimony from our client or other witnesses is just not as convincing as photographic evidence of the scene. We also want to find building code violations. These will make liability a slam dunk. Often we will want to have a private investigator or safety expert go to the scene promptly to document it. This is to obtain photographs, measurements, and coefficient of friction testing if possible. The more evidence that can be obtained before a lawsuit, the more likely we can obtain satisfactory settlement before a lawsuit. Many potential clients ask if a tripping hazard exists when the change of elevation is small, such as less than 3/4 of an inch. There are safety standards that indicate that anything over a 1/4 inch in a height differential is dangerous and needs to be made less dangerous by beveling the edges or creating a slope where the differential occurs. So our answer is yes. A dangerous condition can be less than an inch or 3/4 of an inch in height. Anything over a 1/4 inch is dangerous on a walking surface, especially a sidewalk. The 4th point is obtaining prompt medical attention. That's very important to the value of the case. Delay in treatment is a red flag to most insurance companies. This is especially true for premises liability cases, as the insurance company will suspect that the injury did not occur at the business establishment if treatment is delayed. We are able to provide our clients with medical treatment whereby the medical providers wait to be paid until the case is resolved. This is a major benefit to many people who don't have adequate health insurance or don't know how to secure treatment that they need. And the 5th point, contacting an experienced personal injury attorney as soon as possible is extremely important. Almost always, personal injury attorneys will provide a free consultation. This means you can usually get important advice promptly without having to pay an attorney. An aggressive attorney who is not afraid of handling difficult liability cases such as slip and fall and trip and falls will know what to do best to position the case for success. At the Kohn Law Office, we don't take every premises liability case, but we do provide an initial free consultation on every premises liability case. Since these cases involve sometimes difficult liability questions, including whether the injured person bears some fault for encountering the dangerous condition in the first place, we usually do not take premises liability cases where the injuries are mild sprains and strains that will recover within a few weeks or so. In those cases, we find that the injured party may be better off trying to resolve their case on their own. And we can let them know how to attempt to do that. Here in California, in small claims court, a party can claim up to $10,000 in damages. Therefore, in small injury cases, we often recommend the injured party pursue their own claim in small claims court. However, we do find that many injuries from falls are more severe and include fractures or ligament tears that require substantial medical treatment and even surgery. These are high-value damages cases and should not be pursued without an attorney. The benefit to having a personal injury attorney is that you owe no attorney fee if the attorney does not secure a recovery for the injured party. Often the attorney will also cover litigation costs, and that's something you should discuss with the attorney during your free consultation. So if you or a friend or a loved one has been involved in a slip and fall or a trip and fall case, or you've been badly injured, please call us for a free initial consultation. We would be happy to help. Our phone number is 760-721-8182, and we look forward to helping you.